welcome to this week's Wednesday Wisdom. My name is JB Hilliard, and these are weekly video snippets of information designed to answer questions you may have about estate planning or probate or other legal concerns you may have. And this week, I want to just address those of you out there who, shall I say, are procrastinators or may need just a little bit of a nudge of a help to get started on what you know you need to do as far as your estate planning or estate plan goes. And that may be a multitude of different instruments to use or methods by which you want to distribute your property, your personal belongings, or anything along those lines. But we'll go through that in a second. But what I really want to do is just kind of help those of you who fall into that category to get started. And that's really the main thing, is just get started. And you'll find that you won't continue to put it off once you've actually taken the time to get started. And so I'm going to use that word start as today's lesson, or for today's lesson. So let's start with the S. And that is really for you to just sit down in the moment right now. Just decide right now that this is what you need to do and sit down right now. Now, that's simple enough. But what we find is, and I'm party to this myself, is, we'll look up and we'll plan it in our heads, but then 1 week has gone by, a month has gone by, 3 months, now 6 months. And then before you know it, you look up and a year has passed and you're not any further along in this process than you were a year ago. And it can get very frustrating for you as the planner, but think about how much more frustrating it can be for your family members if something, let's say a year from now, happens to you. Now they're left to pick up the pieces of and try to put together the pieces of your puzzle. And so that's not fair to them. So what you want to do, again, is just get started and start with sitting in the moment right now. Now, what about this T? T is for taking inventory. So when you're thinking about the who, what, and how, that is you taking inventory. So the what may come before the who, or the who may come before the what. So what do you mean by that, JB? Well, let me give you an example. So when we're talking about a will or a trust or things along those lines, where you're actually distributing some properties or assets or things to your beneficiaries, sometimes it's easier to think in terms of what that thing is, that piece of property or memento or whatever it is, to think in terms of what first, and then you'll decide who gets that or who should that go to. Some other times, or in other instances, the who may come first. So for example, let's say you're thinking about, after you've sat down in the moment, now you're thinking about who to assign or call your agent, your healthcare agent, for your healthcare directive, advanced healthcare directive, or your living will. Who's going to be that person to help make those medical or health related decisions for you or on your behalf? So the who may be relational, that person that's closest to you, that knows all about your medical history, knows what prescriptions you're currently on, knows what you're allergic to, food wise or medicine wise. Those types of things you need to consider. Or the who might be a geographical consideration. So if that person that's really the closest to you as far as knowing the most about you and your health care, maybe that person is 3 or 4 or 5 states away from you geographically. So maybe it might not make sense for them to be your primary agent because they can't get to you fast enough, or they can't get here in person to help out if you're incapacitated or unconscious or in a state of mind where you can't make those decisions. And the doctors or the nurses or the healthcare professionals need some immediate answers. So you have to figure out the what and the who and which order that goes in. But that's you taking inventory. Now, where are we? STA, start. A, You might get to a point, or let me back up a second. You may start off saying, I could do this myself. I don't want to spend all of this money to a lawyer when I know I can do it myself. There's Google, there's LegalZoom, there's all these other things out there. Granted, that may be true, but you may also get to a point where you may need help. You may have a few questions that need answers, or, the bottom line is a lot of times you don't know what you don't know. And so, estate planning professionals like myself and some others out there that are very good, you may want to seek the advice of wise counsel to make sure you're not missing anything, or make sure you're not doing something that can't be done, or that you've considered all possible options for your particular situation. Now, moving on to the R, record it. So it's one thing to sit down, to think about things, to take inventory, and to ask questions and get all of your questions answered, or ask for help when you need it. But, all the intents and all the desires and all the wishes are well and good, but they don't do anybody any good until they're written down, recorded, and executed properly. So there are certain instruments that may require certain statutory execution criteria, like a certain number of witnesses. Here in Georgia, a will needs 2 witnesses, or a notarization. So that's part of the recording. You want to make sure you write it down and execute it properly. Otherwise, it's just a thought. And again, the thought goes when you go. So that's not helping your family or your loved ones at all. And then where are we? So we sit down in the moment, do it now, take inventory, ask questions or ask for help, record it, and then tell it. Tell your family, tell your loved ones, tell all of those in your circle who are part of this process, either named beneficiaries in your will, or your maybe you have a power of attorney, a couple different agents named there, or a couple agents for your healthcare directive. But whatever it is, you want to share your intent, share your wishes and desires with your family members and your loved ones. I say that because a lot of times, in fact, I just came across this situation. We had a person who passed away who had no children. She was elderly, but she had no children. And so there were 2 relatives that were going to be co-personal representatives or co-administrators of her estate. They initially came to me and said she didn't have a will. And so that meant that her property was going to be divvied out by among her siblings. Now, fast forward a couple of weeks, and one of the siblings kept digging and digging, and one of the nieces kept digging and digging, and they actually found a will. And that will was nothing that would have been what would have been done under the intestate laws here in Georgia as far as divvying out to the siblings. She had totally different intentions that she had recorded in that will. Thankfully, they did find it and are now going in a slightly different direction, but that they going according to her wishes. And so had she had that meeting with the family, then everyone involved in this at this point in the process would have known, okay, we know she did a will, we got to find it, without having to go through an attorney first and then having to backtrack and change up a little bit on their journey. So we have sit down in the moment right now, take inventory, ask questions or ask for help when you need it. If it can be overwhelming sometimes, record it and execute it properly, and then tell your family and loved ones what you've done, so everyone is on the same page and all the puzzle pieces are put together. So with that said, I thank you as always for watching. Stay safe and stay healthy out there, and we'll see you next time.